welcome all. This is the AKAM webinar on understanding Florida's new SB 4D legislation and the requirements of said legislation. A couple of things before we get started. One is that should you have a question, that we please ask you to put it in the chat and we will get to as many as possible in that. With that being said, this law still, as it is rather unique and also just passed shortly, has a lot of areas that have still not been defined, refined, or gone through some additional questioning. So the information today that we're going to discuss is very general based upon the actual wording of the law as it is now, which may be subject to changes by municipalities, further act by the legislation, or anything other than that. So it is just, we're going to be doing general information, pardon me, and there also may be many questions that are not going to be able to be specifically answered yet. So we will go through those areas as well. And also, I would like to just mention that this will be general information about this bill from both the legal side and the engineering side. However, we also caution all associations to contact and discuss this bill with their association counsel, because there may be things in your association documents that may pertain to this or may pertain to, as we get into the particulars on the reserve study and how reserves are handled, that may be particular to your association. So we, of course, recommend that you contact your association attorney directly for further guidance on your compliance with this law. I'd like to welcome our esteemed panelists. First, we have Lindsay Raphael, who is managing founder of Raphael Law P.A, one of South Florida's most esteemed law firms covering condominium and cooperative association law. And we're also welcoming Samie Hatim, who is the lead project manager for Epic Forensics and Engineering, one of also South Florida's leading firms in terms of engineering, reserve studies, structural inspections, and the like. So at this point, what I'd like to do is kick it off with Lindsay, who will start from the legal end, and then we'll be discussing basically the three major components of the regulation or the law, which is the milestone requirement inspection, the structural integrity reserve study, and then the DBPR reporting requirements. And then, as I said before, we will be having a Q&A at the end. Again, the Q&A will be as much as information as we can. In answering, there will be a lot of questions that will be left to further information, as Lindsay will also address. So without further ado, I would like to introduce Lindsay Raphael, and we'll start off with the legal perspective.
Thank you so much, Doug, and thank you to AKAM for having me here today. It's always a pleasure working with your team and such a wonderful and also high esteemed property management company here in Florida, well, actually in the nation. So thank you for having me here. Yes, obviously a lot of people are very stressed out about this new bill. It's very new. I am in touch with several attorneys in the industry that specialize in what I specialize in. Is everybody is dissecting this. I've actually just been appointed to the task force, which is the group of attorneys who will be working on dealing with some possible changes to the bill, maybe closing some loopholes, further clarification on some things that may not have been fully clear. So I would say I am knee deep in what is going on with this legislation, but I think it is good that very early on people are having this conversation because, as we all know, there are certain requirements here, which I am going to discuss, and there are only so many engineers in the state. So these are the types of things that the boards are going to have to start acting on, I think, sooner than later if it applies to you, so that you can make sure you have time to engage an engineer, have time to negotiate the contract, and know that this is on the calendar to start before there isn't time to hit these deadlines. So I'm just going to start with the milestone inspections. First of all, this applies to condo and cooperative buildings that are 3 stories in height or more. If you are a single family home, these requirements do not apply. I think it is also very important. And let me just say this, you may see me looking down. I don't normally like to read things when I'm giving webinars, but there's a lot of information and I want to make sure that I don't miss anything today. I do want to point out, as everybody knows, you have 40-year certifications. What we are going to talk about today is not in place of your 40-year certification. They may be going, these requirements may happen at the same time. They may cross each other. But just because you've recently had a 40-year certification and you've completed all that work, that does not mean that you're not going to have to do these milestone inspections. Hopefully what it will mean is that whatever needed to be caught was caught in your 40-year, and perhaps you did enough of the work that when you do the first milestone inspection, maybe there might not be as much, maybe there might not be any structural issues at all, but you're still going to have to do this milestone inspection. So the first milestone inspection is when your building either is 30 years of age, and that is based on the original certificate of occupancy, or no later than December 31st, 2024. So if you're an association, if you had a certificate of occupancy that was issued before July 1st, 1992, then the initial milestone inspection must be performed before December 31st, 2024. So that's our hard end date. So first milestone inspection is when your building reaches 30 years of age based on the certificate of occupancy, and then every 10 years thereafter. But if your condo or co-op is within 3 miles of the coastline, your first milestone inspection is going to be at 25 years based on your certificate of occupancy, and then every 10 years thereafter. A common question that has come up is what's considered the coastline? Unfortunately, this statute does not have a defined term for coastline. The conservative approach would likely be that if you are on the water, whether it is the intercoastal or the ocean, from the closest point to the water, you would start to count your 3 miles. That is probably the most conservative approach. There are some definitions of coastline out there that would be based on the ocean side of the property. This is one of those things that you definitely want to reach out to your attorney and get an opinion as to what likely applies. But hopefully this is something with the task force. I know that this is a particular issue that we do want to have defined, what is considered to be the coastline, and also what is considered to be 3 stories. That's another question that everyone has, because stories is not defined, and you can have a building that might have 5 ramps for a garage, and your homes don't start until maybe the 6th floor. What is considered a story? So unfortunately, I cannot definitively answer that for you. I would probably, and I'll let Samie touch on that based on from an engineer standpoint, what the engineer would consider to, or Samie, actually, maybe now's a good time for you to jump in there. What do you guys consider to be 3 stories?
So we would consider any floor above grade. So if you have, 2-story garage and 1 story of residential space, that are 2 floors of garage, 1 floor residential space, we would consider that to be 3 stories.
All right. So once you're off the ground, you're a story.
Correct. I mean, again, that's we're taking that as a very conservative approach, because we just don't know what their story is.
And there are many associations that will have ancillary buildings. Like, for instance, there are associations that would have a separate fitness center building or a cabana building. Typically those are 1-story structures, but there are some out there that may fall under this 3 stories or above if you have a multi-level ancillary structure. So just keep in mind that it's just not your main tower or towers, as the case may be, but also what we term outbuildings of 3 stories or above as well must be part of this milestone inspection.
The phase 1 milestone inspection has to be conducted by a licensed architect, an engineer, and it is a visual examination essentially of the envelope of the building, the habitable, the non-habitable areas, to determine if there appears to be any structural integrity issues with the building. I'd say I think it'd be unlikely, especially if you haven't recently done a 40-year certification, that something won't be found. So most, especially even from like a liability issue, I can't imagine that just from a visual inspection, and Samie, again, you know, you can opine on this, but I would think from a liability standpoint that just from a visual inspection, it's going to be really taxing on an engineer to affirmatively say they don't think that there could be possibly a structural integrity issue, because that is a pretty basic visual inspection at that point. The second inspection, if there is a phase 1 inspection that shows that there's structural issues, the next is called a phase 2 inspection. And that is, and I'll just read it so that everyone, you know, understands. Again, that has to be performed by a licensed architect and engineer. There's nothing out there that says whether it has to be the same architect or engineer, but I think it would make sense to have the same consistent person who's now familiar with your building going back and doing the second inspection. But the statute says a phase 2 of the milestone inspection must be performed if any substantial or structural deterioration is identified during phase 1. A phase 2 inspection may involve destructive or non-destructive testing at the inspector's direction. The inspection may be as extensive or as limited as necessary to fully assess areas of structural distress in order to confirm that the building is structurally sound and safe for its intended use, and to recommend a program for fully assessing and repairing distressed and damaged portions of the building. Upon completion of these milestones, the engineer or architect who performs them is going to do an inspection report with a separate summary at a minimum, showing the material findings and recommendations in the inspection report to the condo or co-op and to the building official of the local government which has jurisdiction. Again, we're not really, I mean, it's probably going to be your local building department, but they've kept that very vague as well. So I'm not quite sure if when we do some amendments to this statute, if that's going to be a little more clear who has the jurisdiction. But that's going to be the process. These reports must be kept on the official records for 15 years. They have to be, if a renter wants to see them, you're going to have to show them. That will be a document that a renter actually has the right to inspect. If someone is selling their unit, my understanding is that the FAR bar contract to sell is in the process of being amended to include these documents as part of the documents that have to be provided to someone upon the sale. And these requirements, you know, will be applying to developers as well. There is one thing I want to say here, though. So we all know that we have this December 31st, 2024 kind of drop dead date that these milestone inspections need to start. However, you may be an association who might get a letter from your local building department or the local enforcement agent who might say, we believe you qualify for the inspection. You have 180 days after receiving this notice to complete phase 1 of the inspection. There are some associations out there that are getting these notices. It would be up to likely the building department to determine that, you know, you've hit your 30 years past your certificate of occupancy, and they're going to want you to go ahead and essentially start this now and be done in 6 months. So you could see something like that come in the mail, because I know that there are some associations who have started getting that.
And this would be something where you would want to consult with your association's counsel for guidance as to the 180-day from the notice of letter or the December 31st, 24 cutoff date.
Yes. Now, the association does have some responsibility here. First, getting these inspections is a fiduciary duty of the board. So failing to do it could be a breach of your will likely be a breach of your fiduciary duties. Also, once you get the report, the association is required to distribute a copy of the inspector prepared summary to each owner regardless of whether there's findings that there's an issue with the building, and it needs to be given to the owners by either United States mail, personal delivery, or email to unit owners if they previously consented to be able to get association communication through email. So that's important. And must post a copy of the summary in a conspicuous place on the property, and must publish the full report and inspector prepares summary on the association's website if you are an association that's required to have a website. So clearly you can see this is about transparency. This is about safety. They want to make sure everyone knows what's going on, and the board is going to be held accountable. This is a common expense of the association. So this is something that you should be having in your budget, anticipating that you're going to have to do, hire an engineer to prepare these reports. The Board of County Commissioners can also prescribe different timelines that may have different requirements. And if the Board of County Commissioners they could adopt an ordinance requiring that an association schedule or commence repairs for substantial structural deterioration within a specified time frame after the local enforcement agency receives a phase 2 inspection. So while generally, so if it is determined in your phase 2 inspection that you have things that need to be done, no matter what, you're required to have those commenced within 365 days of receiving the report. Okay. So once you receive your phase 2, if you have structural issues, you must commence those repairs within 365 days. But the Board of County Commissioners in your local community can set timeframes that might make that shorter. Okay, so that's again something that the attorneys and you want to be watching out for, depending on what county, what city you're in. So I mean that pretty much sums up the milestone reports. I'm just going to say failure to complete the milestone inspection is a breach of the director and officer's fiduciary duty to the owners, which opens up each board member to liability and possible personal exposure if it was with knowledge. So this is, it's here. Maybe in a year it'll change if there are changes to the statute, but this, as of right now, is something that you're going to need to deal with. And I recommend that you don't wait until the end of 2023 to be dealing with these issues, because just like your 40-year certification, if you wait 6 months until it's due, it's going to be too late. You're never going to be able to hire someone in time to get this done.
Samie, before we go on to the structural integrity reserve studies, I've gotten a lot of questions from associations, and maybe we could have, from your perspective as an engineer, what are you going to be looking for in that milestone? Particularly phase 1, and then what's going to trigger, in your opinion and in your practice, when you bring in that phase 2, as opposed to, say, a building that recently, because of the unfortunate incident at Surfside, had what they would characterize as a structural inspection of their building. So if you could just opine on, from a practical engineering standpoint, both the phase 1 and phase 2, what you will be looking for and what the visual versus additional testing may entail.
So as far as the milestone inspection goes, it's primarily structural. We're looking at the life safety of the building. We are looking at structural members. We're looking at the concrete slabs. We're looking at the facade. We're looking at windows. We're looking at everything that may become a life safety issue for the building. So that includes going into habitable areas, going into units. We don't anticipate having to do a full evaluation, such as examining every square inch of the building. We anticipate it being just a visual representative sample of the building. So here at Epic, we tend to take 20% as a representative sample. So we would go into 20% of the units, try and evaluate 20% of the facade as best as possible. And again, it's all visual. The the legislation stipulates that this is a visual inspection, so we're just looking. If we can't see anything, if there's drywall over a wall and we can't if we can't see the wall, then it's not a part of the evaluation. So where phase 2 comes into play, say we come across a crack in a slab and we're not sure where that crack is originating or why it's there, whether it's a stress crack, whether it's from corroded rebar, whatever the case is. At which point that would kick off phase 2. When we hit phase 2, that's when we hire a contractor. Contractor comes in, and in a prescribed manner, they'll start removing concrete so that we can see what's going on. So the purpose of phase 2 is exploratory, to get an idea of the condition of the building from a much more deeper sense. Again, it may not be required, but based on what you were saying earlier, most likely will be. But that's going to be based purely off of phase 1 inspection.
Right. Thank you. And now I think we'll move on to the next part of the legislative is the structural integrity reserve studies. And I'll kick it back to Lindsay on this to start off, and then we'll go back to Samie for the engineering viewpoint.
Thank you. So again, and I haven't been looking at all the questions because it's hard to talk and look at the questions, but again, these requirements that we're talking about today apply to condos that are or cooperatives that are 3 stories or higher. I saw someone was asking for 2 stories or less. 2 stories or less is not 3 stories or higher. So this, as of right now, is not applying to a 2-story condo, okay? That doesn't mean you still shouldn't be getting, doing what you need to do to keep your building safe, but you're not going to be bound by this new statute. So every association must have a mandatory structural integrity reserve study of any building 3 stories or higher by December 31st, 2024. And you can see here on the screen, these are very specific structural integrity reserve items that now the state is saying these need to be specifically reserved. They consider it to be part of the structural integrity of the building. Some of these were items that before you were able to reserve for and waive or partially reserve for. These items cannot be waived or reduced, at least not at this point, based on how the study is. So your roof reserve, your load bearing walls, your floor, your foundation, fireproofing, fire protection, plumbing, your electrical systems, waterproofing and exterior painting, windows, and any other item that failure to replace essentially could impact the structural integrity of the building, you are no longer allowed to put to a unit owner vote to reduce or waive, okay? Now, again, this is a little bit of an issue with how it was drafted. It is unclear on the statute, based on the statute, if every condo must, I'm trying to figure out the best way to explain this. So we know for a fact that if you are 3 stories or higher, you have to reserve for these structural items. What's unclear is if you are less than 3 stories and you're not required to do the structural integrity study, but you're still reserving for these items if you can reduce or partially reserve those. I recommend you talk to your association's attorney. The conservative approach of some attorneys has been, these are things that you can't waive. Some attorneys are taking the position that these only apply as being in the category of structural integrity reserves if you're 3 stories or higher, and if you're 3 stories or higher and you have to do these reserves, it's in that instance that you can't waive them, okay? So again, that is something that we are going to try to clarify in, I don't really want to call it a glitch bill, but in some changes that we're going to make as suggestions to this statute. It is, so By December 31st, 2024, every condo or co-op must have a structural integrity reserve study completed at least every 10 years after the condo was created for each building on the condominium property that is 3 stories or higher in height, and it has the minimum of those. The structural integrity reserve study must identify the common areas being visually inspected, state the estimated remaining useful life and estimated replacement costs or deferred maintenance expense of the common areas, and provide a recommended annual reserve amount that achieves the estimated replacement costs or deferred maintenance for each of these items. Again, these are items that cannot be waived. It is unclear if this applies to all condominiums or cooperatives or only just those 3 stories or higher when it comes to waiving. Who can perform the structural integrity reserve? So this is interesting because prior to this, anyone could have done your reserves. There are companies out there that do reserve studies. They're not licensed engineers. They're not architects. But for the structural integrity reserve study, it has to be performed by a person qualified to perform the study. So it's going to be a Florida licensed engineer or Florida licensed architect. How long must the structural integrity reserve study be kept? The association has to keep it for 15 years after you receive the report. It's part of the official records. It is open to inspection, and it also must be posted on the association's website. It is part of the board's fiduciary duties to get this structural integrity reserve study. And it also, this new law also applies to developers. So before a developer turns over control of the association to the owners, the developer is required now to get a structural integrity reserve study completed for every building that is more than 3 stories or more in height. And in addition, prior to turnover, the developers cannot vote to not fund reserves. Also, associations existing on or before July 1st, 2022, which are controlled by unit owners other than the developer, must have a structural integrity reserve study completed by December 31st, 2024 for each building that is 3 stories or higher. So if you've been in existence before July 1st, 2022, you've got to get this done, and the deadline is December 31st, 2024.
Lindsay, in one of the some of the questions that we as managing agents have been getting since this came out, and since we're on this particular the structural reserve study, and again, this may be a question that is still in a gray area, or needs to be clarified, or needs to be opined on by the association in particular as counsel, is one of the questions that we've been asked is concerning windows in particular, where you have an association that their association documents put the windows, forgetting common area for the moment,
Right.
put the windows within the units, windows and say doors, as the responsibility to maintain and replace to the
Right.
individual apartment and to the individual condo owner. So at this point is, where do we stand on that, if at all, or if this needs to be clarified as to whether those elements will need to be included in the structural reserve study funding, or is that are we only going to take the stance that it is common areas?
Yeah, I mean, that's a really good question. And honestly, it's a question that many of us have been discussing, even on the task force when we met last week. There are a few items on here that we would love to maybe see excluded if there's an amendment, such as the floor, the foundation, and that it be clear that this applies to those items that the association is responsible for making repairs and replacement to. Some people have raised, just for example, with foundation, you can't, and Samie, I mean, jump in here, but you can't replace the foundation without like affecting the entire building. I don't know how, I mean, Samie, how do you like fix the foundation without it impacting, like removing the structure?
There are methods of going through the top of the slab and also boring methods, which would go underneath the slab. But
Okay.
seeing an issue with the foundation is very difficult as is, because your floor is always going to have tile, carpeting, some sort of overlay. So because it's this a visual study, unless we see crack patterns or something along those lines in that in that overlayment,
Right.
we're not going to be able to see anything unless, you know, it'd have to be pretty drastic for us to really see anything. So if there are issues with the foundation, it's going to be very evident. And if those repairs need to be made, there are methods of repair, but it's not cheap. But at the same time, you got to do it for the life
Yeah,
of it.
I mean, and that's why some attorneys are saying that, the foundation should, you should be reserving as more of a repair item, not a full replacement item, because you can't really replace. I mean,
Right.
you can repair, but you can't replace.
Correct.
But I can't even, I'd love to answer the question on windows right now. Common sense tells me that this is intended to be what the association is required to maintain, repair, and replace. That is what all the reserves are for. But again, you can't put words into a statute that don't exist. So this is another thing that we certainly want to clarify.
Now, Lindsay, I don't believe the statute is silent on it. But what should an association, once this structural reserve study is done, what is your counsel, and maybe also Samie, to opine on this as a firm that does do these studies? Once it's done and obviously distributed, how often should updates be done?
Well, the statute actually says it has to be done every 10 years.
Right.
However, I mean, it says every condo must have a structural integrity reserve study completed at least every 10 years. But I mean, if you do a roof replacement, that's going to start. I mean, there's a specific formula for determining what you're supposed to be reserving, and you're required 100% reserve. So if you've used it, I mean, I would think that some or all of a portion, you would need to do another reserve study to find out what's the appropriate amount you're supposed to be reserving, because it's changed.
Right. And also, I think it is responsible to associations to do an update further than, let's say, a 10-year time frame is mandated, because things do change, things do happen in the building in the course of those years, and you want to get an update. Usually, we've recommended every 2 to 4 years that they update their reserve studies. So again, not necessarily required, but might be a good practice.
Well, the requirement's going to be 10 years. And I mean, certainly as we see now, even in the industry, there's fluctuations in pricing and inflation. What it's going to cost to do a roof today and what it would cost 10 years ago, I mean, it's going to be different, and it's going to be different 3 years from now. Hopefully, maybe it'll go down, but who knows? So yes, I don't think you need to commit to doing it every 2 years. I think that's a lot. I think if you have, and Samie, again, this would probably be more your area than my area. The legal requirement is going to be 10. From a common sense standpoint, as you're using that money and fixing things, and you have this requirement to be fully funding, you're not fully funding if you don't know what those new amounts are. So I'd probably say at least every 5 years, or if you're done with a huge project, you need to know what that new number is.
Right. So I personally recommend 3 to 5 years. And then after a major project, say you do a facade restoration or a cooling tower replacement or something along those lines, any major project like that, I would always recommend doing a reserve study after that to update your reserves.
Samie, do you have an idea of like how much these reserve studies typically run? I mean, I know it obviously changes based on the size of the building and stuff like that, but what's like the lower end of the spectrum of what these can cost?
Lower end with the full structural inspection as required by the structural integrity reserve study, I can't see it under $6,000, because you do have to have a licensed engineer or architect do a full inspection, do an inspection of the building, not just structural, but including all these other items, on top of what is normally inspected over the course of regular reserve study. So.
And can you combine the two? So, I mean, I would think it would make sense for an association. If you're getting a structural reserve study, just bang it out. Have the engineer do your structural integrity reserve study, your regular reserve study, have these two categories. These you might be able to waive or partially reserve. These are required, and just get everything done in one swoop.
Absolutely. I fully agree with that. And that's what I always recommend people doing. It's, we're going to be in there. We're going to be walking the building anyway. You're going to be writing the report anyway. You might as well include the rest of the items in there.
I agree.
And I think one of the things to also note, as you noted, Lindsay, before, is that there are a number of firms that over the years have done and that are particularly done reserve studies. And, you know, there are a lot of companies out there, but now all associations need to make sure that when they perform this structural reserve study, that it is being done by a firm that is qualified to do it. And we're seeing a lot of the reserve study firms now aligning themselves or partnering with licensed engineers and architects.
Right.
So that just to make sure an association makes sure that when they enter into a contract, that it is implicitly stated that this will be satisfying the regulations under the structural reserve study.
Yeah, and I'm sure with your relationships at AKAM that you know you're going to have some referrals. Obviously, this is something that Samie and his team can handle, but that's why I'm telling my clients, I can't promise you that you might not waste some money in the next year if the statute changes, but I can't imagine that the statute's going to change that dramatically, that there aren't going to be these requirements. Maybe there'll be a few changes in what those items are. Maybe there's going to be clarification on coastline, stories. Does this only apply to association responsibilities? But I don't think that this entire statute's going to be scrapped.
And you don't see any, you know, we have other statutes that have come down the pike that have then been extended upon extension, in particular, the ELSS and the BDA. And in this one, it just from my experience, and maybe in Samie and you guys, you can opine on this, with what happened at Surfside, I don't see this as one of those where this is going to be open to an extension, unless there's something that comes up legislatively that, you know, buildings just are impossible to meet the deadlines. But I don't think this is something that's going to be extended out 5-10 years from now.
I haven't heard anyone talk about extension dates. So I think you have to assume at this point you need to comply with it and start talking to an engineer, because it's going to take time. I mean, all of my associations that end up not having their 40-year certification done on time isn't because they didn't want to do it. It's because they waited too late to start the process. By the time they were done engaging the engineer, negotiating the contract, I mean, sometimes just negotiating the contract and getting it signed can take 3 months. So by the time you're done doing that and then getting on their book for being able to start the work, I mean, maybe it's going to be 9 months out. And then it's going to take the engineer time to do the job and get it done and have the report and you turn it in. I mean, to me, it sounds like this is a 2-year project anyway, even if you started today, by the time you're done with everything.
And one of the questions that we've gotten today on the question is directly related to this, in the sense of the question is there a new definition for the inspection? And if we had an engineering inspection last year, would that apply for this, or is there a new definition for this inspection? Well, the definition is as per this legislation, which is a little different and which does require certain phase 1 and phase 2, which may have been from a practical standpoint done by your engineer in that initial inspection. This now becomes a separate inspection. However, that being said, if you had one recently, then using the same engineer that did that to now do this milestone inspection would probably be the best case because they are familiar with the structures within your association.
I mean, just because you had an inspection a year or two ago, you have to comply with the milestone. Now,
Correct.
maybe, and again, Samie might be able to jump in here. Maybe if you had your inspection a year ago and your engineer is comfortable and comes out and just does an update, and so then they prepare this particular milestone report, maybe they'll be able to piggyback off of what they did, but like, you're still going to have to do this report, and your engineer is going to have to be comfortable because the engineer has liability. So Samie, how would you handle that if an association asked that of you?
I think you'd be hard pressed to find an engineer that wouldn't want to come back out for another site visit,
Yeah.
especially after a year. You know, most engineers wouldn't go past 6 months.
I mean, this is liability. So no one is going to want to put their sign, their seal on something that, because things change, especially if you have development around the area, you have other buildings going up around the area, you know, the ground shakes, the foundation, like things change. And what could have been a year ago might not be today. So that's why I also say the same thing with your 40-year certification. Just because the county has a 40-year certification statute, that does not mean that you don't have to comply, even though some of these things may cross over. You may have just finished your 40-year certification. You still have to have the engineer come out and do these milestone reports. So now you may have 2 reports you have to do. You have to do your 40-year and you have to do this.
And I think if you remember, until now, there were only Miami-Dade and Broward were the only counties that required the 40-year. So,
Yes.
you know,
Palm Beach County doesn't have a 40, or
Palm Beach had just passed legislation on it. But one of the things that you just want to, as Lindsay just said, very importantly, this is a new ballgame. These 2 reports, the structural and the milestone, have to be done per this statute. It's no piggybacking onto something else, or if we did this 6 months ago, do we have to do this? It's very clear that these need to be done by the deadlines and treated as a standalone product.
Yeah, and you might have, like, I see this question here about, you know, BOCA issuing a letter that they had to do their 25-year certification by May 1st, 2023. There's nothing in here that says you can't turn in this milestone report early, okay? You don't have to wait till December 31st, 2024. If you are starting to embark on what BOCA is requiring for your 20-year certification, and you're able to use the same engineer, and you can have them, you can meet the requirements of the 40-year, meet the requirements of the milestone, and the engineer thinks that they can combine the 2 inspections, then great. I mean, kill 2 birds with 1 stone. Maybe that's not a good way to talk, but certainly if you can piggyback off the 2, do so. But just because if you finished BOCA's requirements, that doesn't mean you're not still going to have to do the milestone.
Now, speaking about the milestone, a couple of questions that we see on the Q&A is, one is, can you opine on the filing of this in terms of who files it, you know, and in terms of can we file it now? You know, if we're going through a restoration project currently, okay, and we're going to be finishing up within the time frame of, let's say, you know, maybe a few months, and we're going to have our engineer, and our engineer is going to sign off the project. We engage him to do the milestone. Can we file immediately? Can we file early?
Well, there's nothing that says that you can't start this process now. What it says is you have to have it done by a deadline. So, I mean, I can't imagine someone would say, well, listen, you might have structural integrity issues now, but we don't want you to start it yet. We want you to wait a year, and you're only allowed to do it within this 1-year window. I mean, the point is they want people to do these studies. They want you to know sooner or later if there are issues with the building, and they want you to fix it. And the deadline for having all that completed is December 31st, 2024. If you want to start that process now, and in 6 now be able to submit the inspection report to the local enforcement agency. Again, I can't even tell you if that's the building department, because they just use the words local enforcement agency. It's likely going to be the building department, your local building department. But I don't think there's nothing that says you can't start that now. And when it's done, submit it to them. And it says you submit so it says completion of the phase 1 of milestone inspection means that the licensed engineer or architect who performed the phase 1 inspection submitted the inspection report by email, United States Postal Service, or commercial delivery service to the local enforcement agency. So it's your engineer who's going to submit it on your behalf.
There is another question where we have an association that is going to be undergoing a multi-year restoration project. And this is going to encompass mostly every aspect of the building that it wouldn't be involved in, both the milestone and the reserves and the structural reserve study. So how would you counsel a building on in that regard, in the terms of they're going to be doing this, all of these items will be addressed, but it will carry over the deadline for submission of this report. So the submission of the report, as I take it, and I'd like both Lindsay and Samie to opine, is going to be a moment in time as to when the inspection is done. And in a building such as this, what may be a good idea is, when you have a building undergoing such a massive project, is that it has to be done by the deadline. It will be a moment in time as of the inspection. And it may be stated by, and Samie, you can opine on this, it may be stated that construction is ongoing and will address certain items in this. But then again, I would say when that project is done, is to have your structural reserve study redone or amended to include all of the improvements and repairs that you have made. So because it's fully funded, to accurately then determine your fully funded amounts, rather than going with something that would have a shorter lifespan.
No, absolutely, I absolutely agree. It's the milestone inspection absolutely is a snapshot in time. And while the construction is ongoing, I do believe that there is a requirement that progress updates must be submitted every 6 months over the course of the construction. So as the jurisdiction is being updated, they're privy to what's going on and making sure this project is still ongoing. And then once that project is completed, absolutely can have another reserve study completed to update the timeline.
Now, there's still, Lindsay, there's still a little confusion out there. And if we could talk a little more on the reserve study in terms of waiving partially and not be, and having to fully fund. And the question is that, does this statute say it requires fully funding the reserves? And the answer to that is it requires fully funding the structural portion that is dictated by the legislation. If you could just run through that a little bit again.
Let's just start with what the law was before all this, okay? Because I think that sometimes associations don't understand, and some owners seem to think they have this entitlement to being able to waive or reduce reserves, which is not the case. So let's just start with condo law, co-op law 101. Let's pretend we don't have this new law. Okay, you're all already required to fully fund reserves. Okay, the default of the statute is you are required to fund appropriately all of your reserve items. Okay, there's an exception to that, and that is if the board decides that they want to put to unit owner vote to give the owners even the opportunity to partially fund or waive reserves. But if you have a board that says, you know what, we happen to like reserves, and sorry owners, if you don't like them, we're not even going to put it to vote, that is totally within the discretion of the board. So all reserves, not just structural integrity reserves, are already required to be 100% funded unless you receive a majority vote of the membership, okay? So that is your basic reserve law as it has existed for many, many years. Now we have a second part of this. which is now what we're calling structural integrity reserves. And what the new law is saying, okay, you may have some reserves over here that you're still allowed to decide to put to vote to waive or reduce, such as like, you know, your pool pump or your pool, if your pool isn't affecting the structural integrity, maybe the paving of your roadways. I mean, there are still going to be items that the board can decide to put to vote, but the items in these categories, which is in that section G, which is A through J, you're not even allowed to put that to, like, that's 100%. You're not allowed to give the owners the right at this point to decide to reduce reserving that. Okay. And I saw on here, and this goes with what we're talking about. Someone said, well, what's the deadline for 100% reserving? I would say that it says by December 31st, 2024, you need to have these items, you know, you need to have your structural integrity report complete. I would think January 1st, 2025, you're 100% reserving. That doesn't mean that you're going to have the 100% of this amount sitting in your reserve account. It means that when the engineer is done with the structural integrity report, and let's just use 10 years for an example, they're going to say this is the amount every owner needs to be paying per month towards reserves for the next 10 years for you to be able to fully fund these repairs when these repairs are due. That's what the purpose of the reserves are for. And a lot of the discussion around Surfside, and honestly, it's a discussion I've been having with many of my associations for many years, is, you know, everyone wants to kick the bucket down the road. I've literally gone into association meetings where I have had owners tell me, you know, I am on a fixed income, I am elderly, by the time this roof needs to be replaced, I'm not even going to be here anymore. I don't care. I don't want to pay for it. And I think that whether you're elderly or whatever, let's just say you're an investor in the property and you're someone who wants to flip a condo and you don't want to pay for the roof 10 years down the road. That's not condo living. Okay. When you buy into a condo, everyone shares the expenses. And the intent is that you are supposed to be sharing the expenses now, so that when something is needed in 5-10 years down the road, the money is sitting there and the association has the ability to pay for it. And that is how you avoid having these huge special assessments. And I hear owners talk all the time about how they'd rather have a special assessment. They don't want to pay reserves. Well, guess what? I have an association that yesterday passed a $25,000 special assessment for every unit. And you know when it's due? August 1st. No financing, no payment plan. They have life safety issues. They have structural issues, and they need the money immediately. And so there's people that didn't want to pay $100 more a month or $50 more a month. Now I have to figure out how to come up with $25,000 in 2 weeks. So, you know, and I think part of the problem in Surfside, although there were so many problems in Surfside, I mean, that's like one of those like perfect storms where it wasn't just any one thing that caused the damage. But part of the problem is that they weren't reserving and they didn't have the money. And if I remember correctly, like their reserves would have been like, people would have been paying like $300,000 to make up for the deficit to be able to do the amount of work that needed to be done to even get the building where it should have been. So the point of this is, if it's structural, if it's a life safety issue, they don't want people kicking the can down the road. They want, the legislature wants to make sure that when it is necessary to fix these items, that the money is there. And if it's not, you will get a special assessment. But, you know, they want to make sure that these reserves are sitting there waiting for this work to be done.
One of the things too that associations have to realize, you know, the kicking the can down the road idea basically has come to a stop with this legislation in a lot of the structural and life safety areas. And I get asked a bunch of times from associations, well, when should we start preparing for our 40-year? And my answer to that has always been the day your building opens. Because the things that you have to concern yourself with is ongoing repair and maintenance of these structural items. And I think Surfside, unfortunately, with the tragedy, pointed that out better than anything else. So as Lindsay says, and as Samie says, you really need to maintain the building on an ongoing thing. And that's what this legislation is trying to address. We have a couple of more questions before I just want to make sure that we deal with the registration aspect from the DBPR. So
Yes.
before we go into that, let's just finish up with some questions. We've answered in terms of the fully fund and fully funded work to be done. Is the one of the questions that's answered with these additional reporting requirements, is the state going to provide any funding? And
Funding for what?
for any sort of work or for
I mean, to
potentially
cover the association's expenses?
associations that could not afford the work, anything? I have not heard anything.
I
to
have
that.
not heard anything. I mean, these are common expenses, and my guess is if the association doesn't have the money, I mean, I think you have two things going on. You're going to have things that need to be fixed now because your structural integrity, these milestone reports are going to show whether you have something that's going to be fixed sooner than later. So that's number one. And if that's the case, if the association doesn't have the funding, they're either going to need to get a loan or pass a special assessment. And then you have the structural integrity report, which is not there to tell you you need to fix things now. It's there to say, okay, and it's a formula. So I can't give you like an exact dollar amount per item, but it is a specific formula that the engineer is going to use based on, I guess, what they consider to be the useful life of that asset, that by what the useful life of that asset should be, that you need to fund X amount per year in order to be able to pay for this when its useful life essentially is expired. And so when we talk fully fund, understand there's no defined term for that. But I would say in my mind, fully fund means that if Samie says that in order for you to appropriately 100% reserve for all of your structural integrity reserve items for the next 10 years, every owner has to pay an additional $100 a month, then I would say paying the $100 a month is your fully funding, because you're going to have a schedule over a 10-year period of what needs to go into that account. And if you are each month charging 100% of that to your owners, I would say that that's what we generally consider fully funding. It's not paying the total, the $3 million amount on month one. It's paying the $3 million a month over 10 years. And whatever Samie, the schedule is.
And Samie, when you do your reserve studies and you promulgate those schedules, it obviously takes account different aspects of that item, i.e., the date of its initial installation or how old it is, the current condition. If you could just opine a little bit on what you look for when you're determining those figures.
So we look, especially for older buildings, we look at the date that it was originally built, any restoration projects that were conducted previously, and the current state of that asset. So let's say a roof. The roof on a 30-year-old building, obviously it's going to be well past its, just on paper, it's going to be well past its reasonable useful life. Maybe they did a roof replacement 10 years ago at the 20-year mark. Now, that new roof currently has 10 years on it. So we're going to do our evaluation. We're going to be looking for any tearing in the roof, any water intrusion below. So we're looking at several aspects of it. And then we're also looking at any repairs that have been conducted that will extend the lifespan of the roof. So on paper, you may only have 10 years left on your roof, but with repairs that have been conducted, et cetera, you may be able to extend that another 2-3 years. So from a technical side of things, that's what we're looking at. We're looking at original installation, current state, and any repairs or replacements. Mm-hmm. So it's important that the association have those records prior to us coming in and doing our reserve study. Those are some of the things that we actually look at as well.
Great. It's a great point with record preservation. Not only is it going to be apropos with this statute in terms of record preservation with these documents, but any documents that you do with any repairs, improvements on your property, making sure that they're retained for many years so that when an engineer comes in, they have a background on that particular asset. Before we go on to the last part of the regulation, we have one more question. And then again, I think it's going to depend on each municipality, but the question is what governmental entity will be responsible for ensuring each building complies with the reporting requirements? And will they also be responsible for reviewing the reports for accuracy of content? And does the new legislation provide for any sort of stated monetary penalties or penalties for non-compliance?
Okay, so when phase 1 and phase 2 milestone reports are completed, the engineer is going to submit those recommendations and findings to the building official of the local government that has jurisdiction. That is all the statute says. So it's most likely going to be your building department. But again, it just says to the building official of the local government which has jurisdiction. And then it lists at a minimum what the criteria must be. I can't imagine that the building department itself is going to want to take on liability for determining whether the engineer did his or her job properly. They don't do that for the 40-year certification, right, Samie? All they do is the engineer goes, inspects, does the report, makes recommendations, submits it. And what the building department is concerned about, or I should really say what code enforcement and your county commissioners are concerned about, is making sure that you're finishing it within a certain amount of time. When you start getting those fines penalized, start getting fines against you by the county commissioners, it's because they want this work to be done, and they usually extend it based on like 180-day periods, but they give you these windows of like 6 months, and you have to keep going back to them, showing them how far you've come during those 6 months, because they want the project to be done. I am assuming, and again, it's an assumption, that this would probably be very similar. But instead of being a local ordinance, you now have a statute. So, I mean, if you're in breach of this, the association's in breach of the statute. So, I mean, the building department's going to be involved, but I don't think they're going to be overseeing and double checking the work of the engineer. And as far as penalties, to be honest with you, I've read the statute a bunch of times, but I didn't see a specific penalty. I'd have to go through it again. Every time I read it, I come up with something different that I see. I'm like reading it all the time. It's not the easiest of statutes, and it's very long. But I think that you'd have to assume that you certainly could get hit with fines from the county. The association could be sued by an owner, and I'm sure there will be some kind of financial penalty, but I couldn't tell you at this point what it is.
Okay. And we have just one last question, which is very concerning the reserve funding. And the question is, so come January 1 of 2025, we have to fund 100% going forward on those items. But if we should have had $1 million in reserves and only had $500,000, do we need to special assess to fund the delta?
I wish I could answer that. Statutes are not retroactive. They're going forward. So I would believe that this would be something on a going forward basis, that as of that date, after you've done the structural entire, I don't think they're going to make you go back and fund a deficit. That's not what the statute says, and the statutes are not retroactive. So I haven't seen anything that says that, but I can't 100%. I mean, my guess is that it's going to be from the time you get your structural integrity report forward, you're 100% funding and no longer have the option to waive or reduce those specific items that are considered structural integrity reserves. Samie, have you heard anything?
No.
How about you, Doug?
No, that's what I've said. What I've been hearing, is coming closer to what you've said. It's going to be the moment in time when the statute says it's due by, and going forward from that date would be the date where you would have to do the fully funding. Again, something that you may want to discuss with your individual association council as well.
And I'm going to make note of that. I'm going to bring that up to my task force, just so that's why I'm looking down for a second.
Now, before we end this informative seminar, I just want to touch on probably the one that's most clear yet simplest of the new statute is the DBPR reporting requirements.
Yes.
So Lindsay, if you could just give a short background on that. And even with that, you've just heard, as we were discussing before we got on the webinar, that they've already said that they're not going to have the vehicle in which to do that until later in the year.
Yes.
And that's going to be due by December 31st of this year. So that's something that's going to have to be worked out with each association to make sure you comply with that deadline. And it's a rather simple thing to do, but we just have to make sure that all associations are in compliance.
So this is a DBPR reporting requirement. It is something that is going to apply to all associations. I do not believe that this is limited to 3 stories in height. Okay. Essentially, on or before January 1st, 2023, all condominiums and cooperatives that are in existence have to provide the following information to the DBPR, and that is the number of buildings on the property that are 3 stories or higher in height, the total number of units in all of those buildings, the addresses for all the buildings, and the counties in which the buildings are located. The DBPR does not have a form yet for this. My understanding is they intend to have a form by October that will be like some of these other DBPR forms that you fill out and get filed. It is something that you could, I believe, choose to do now if you want to submit it. But what I have been told is you better make sure that the name of the association is very clear on the document. That's all I've been told. So this is something like if you want to provide a letter and call it DBPR reporting requirements and have it typed out and make sure it is very clear. But I will tell you that even if you do that, if there is a form that comes out in October, I'd probably resubmit it anyway, or get something in writing from the DBPR confirming that they consider you to have be in compliance with this reporting requirement. So this is going to be the first deadline out of all of these that's going to come up, and it's going to be the end of this year.
And that's going to be something there that, you know, and I think, Lindsay, you make a very good point. If you are going to submit early on this in a letterhead, or maybe it's something that your counsel prepares and files, when they come out with the actual form, and hopefully it will be able to be done online, we hope, then we just still recommend also as managing agents that it be done again through the official form and through the official methodology as set forth by the department. With that, I would like to thank all our attendees. I hope we've answered some of your questions that we could. As Lindsay and Samie have indicated, there are still some gray areas. There may be some changes to the statute in which we will keep everybody advised. And if you do have any questions on this slide, you can see the contact information for all our panelists today. And on behalf of the webinar, on behalf of AKAM, and on behalf of our associations, I would like to thank you, Lindsay, and thank you, Samie, for the invaluable information that you gave to our managers and our associations today. And I look forward to additional information, which maybe in the future, if we have some major changes, we'll come back and revisit this subject with updates.
Absolutely, absolutely. And I will make sure that I keep you posted as I'm seeing changes come through. So thank you so much for having me today. I love, doing these webinars, and I enjoyed it. And certainly if anyone has any questions, they can reach out to me. If you are an association represented by counsel and you have specific questions having to do with your property, your reserves, certainly direct that to your attorney. If you do not have an attorney and you're looking for legal, please feel free to reach out to me. And I appreciate the opportunity.
And Samie, thank you for the insight from the engineering standpoint. And I take it that you guys won't be getting much sleep over the next couple of years.
I haven't been getting much sleep for the past few weeks, so we're already there, but it's a pleasure to be here. If anybody has any more questions for me, please feel free to shoot me an email. Be happy to correspond with anybody here.
Okay, great. Again, thank you to all our attendees. I hope this has been informative. Thank you, Lindsay. Thank you, Samie. And have a good afternoon, everybody, and stay safe.